time to be with us today. I thought I would go around the room just to welcome everybody to the meeting and just try to be as swift as I can with that, so I can acknowledge and welcome people and be ready to move on to tackling our agenda. For today's meeting, we have the ability to hear an update from the research unit here at OPM Criminal Justice regarding the latest monthly indicators in the criminal justice system. And we also have an update on the new reporting methodology for how we count arrests. And we're grateful for partnerships with the CJPAC and the judicial branch to update that information. I've long felt that arrest is a critical part of the monthly because it gives you a front-end system indicator that could have impacts further down in the criminal justice system. Very good. I believe I just muted someone on the phone. Sorry for my rudeness, but there's a bit of feedback. Please feel free to come back on off mute when you need to, or if that situation's been addressed. And then after that, we're fortunate to be joined, headed up by Chairman Giles and Director Sparacco from the Board of Pardons and Paroles, and Chief Public Defender Chris Rapillo from the Division of Public Defender Services for an update on sort of a year and a half in to implementing a pilot to provide representation to people at parole violation hearings. This has been a significant effort from both agencies to really deploy staff in both of those agencies to set up this unit. It's a small unit that has provided really significant reach at the parole violation process, and it is something that was many years in the making to reach that point. So we're eager to hear the update from our members on that topic. I've also invited Fiona Doherty from Yale Law School, Samuel Jacobs Clinic, and I believe she is on the line, and we are so grateful to have her here because part of the story, a key part of the story of the formation of this unit was the efforts of the Yale Law School Samuel Jacobs Clinic, whose students observed violation hearings and interviewed people appearing at those hearings, and the analysis that was conducted by Yale Law School informed the creation of this unit. So perhaps when we begin our that section, I might turn to the professor just to ask if she has some insights to share, and of course we're hopeful that along the way she will share reactions and questions. So please feel free, everyone, to use the hand raise feature on Microsoft Teams to ask any questions. I'll try to keep an eye on it. If you don't have that feature on your Teams, or it's just either easier for you, feel free to come off mute and ask me, or just jump into the conversation. I don't want to stilt our discussions to too great a degree, knowing that we're in a virtual format. I do try to encourage as much flow of conversation as I can under the current circumstances. So I'll just go through quickly to say a quick hello to everyone I see. I'm so pleased that Brian Foley is here from DSPP. Thank you for being here, sir. I'm glad the commissioner's doing okay. I know it's been a hectic week with a lot that he's been managing, but we're grateful you're making time to be here. Thank you. And Chief Public Defender Chris Rapillo, grateful you're here, and members of your team for the presentation.
Good morning.
Good morning, ma'am. Director Begg, glad you're here from CJPAC. And good morning, good sir. From DEMIS, Chris Burke, very much glad you're here. Deputy Forensic Services Director, glad you're here.
Good morning, sir.
From the DOC, I see we're well represented with Deputy Commissioner Sharonda Carlos. I'm glad you're here, ma'am.
Good morning, sir.
I see Commissioner Quiros is here too. I should scroll down a little further before I jump to begin introducing folks. So glad you're here, Deputy Commissioner and Commissioner Quiros.
Good morning, Mark. Good morning, group.
Sir. Commissioner Rebell, in fact, I see you're here. I spoke of your name earlier and you were here. So glad you're here.
Good morning, everyone.
From the board, I don't see the chairman just yet, but I do see Rich Baracco and some members of his team here that are also joining.
I am here. Good morning, all. Good morning, Mr. Secretary.
Oh my gosh, Mr. Chairman, so nice to see you, sir. And
Good morning, Mark. How are you?
Rich, doing great, sir. Glad you're here. From the judicial branch, Judge Carroll, good morning, sir.
Good morning, Mark. Hope you can hear me.
Loud and clear, loud and clear.
Good.
And Gary Roberge from CSSD Director, glad you're here. Good morning.
Morning, everybody.
Very good. And then from the school State Department of Education, John Frassinelli. Good morning, sir. Glad you're here.
Morning, everyone. Mr. Chair.
From the Coalition Against Domestic Violence, Jerry Weil. So happy you're here. Good morning.
Good morning, everyone. Happy Thursday.
Happy Thursday indeed. We're going to reach the 70s today. Gets better and better. Yay. From the Alliance to End Sexual Violence, I see both Nina Vasquez, who directs the collaborative model, post-conviction services, and I also see Lucy Nolan, Director of Public Policy. Good morning.
Morning. And Beth is trying to get in. She's having some technical difficulties.
Happens to us all. Happens to me too.
Good morning, Mark. Good morning, everybody.
Hi, good morning, Nina. So happy you're here. And I know I'm certainly missing folks, so I will, in just a quick second, just invite anyone to say a quick hello. I have bypassed the Chief of Police from Vernon for a reason. I did want to share that some news that he had provided to me with the group. But before I turn to the Chief, would anyone who I have omitted introducing and who wishes to say a quick hello, please feel free to step on and say good morning to everybody. The floor is open.
Hi, thanks the DVA.
Good morning.
Lori, Public Member. Nice to be with everyone, and if only via audio.
Oh, understood. We're glad you're here.
Good morning, everyone. Eulalia Garcia with the Department of Correction.
Good morning, DA Garcia. So
Good
happy you're here.
morning. Thank you. Good to see all of you.
Morning, everyone. Bill Mulligan, Deputy Commissioner, Department of Corrections.
Morning, DC Mulligan. Glad you're here.
Good morning, Mark.
And then I skipped over when I was going through Demas. I didn't say hello to Dr. Norco. Good morning, sir.
Good morning, everyone.
And from the Department of Veteran Affairs, Ms. Siegel. Glad you're here,
Hello.
ma'am.
Hi, everyone.
Very good. Anyone else want to say a quick hello as we get started?
Good morning, Undersecretary Proca. Eric Ellison from Department of Correction.
Director Ellison, so glad you're here, and we are certainly eager to hear from you and your colleagues in the department, but especially from you from Rural and Community Services when we get to discussing the kind of the pilot program for representation. It'll be really great to hear your insights, and thank you for making the time.
Thank you.
Very good. And I am so happy from the Coalition End Homelessness. I heard that Sarah Fox could not attend, which of course was sad news. But then I heard that Omina McCoy would be perhaps representing the coalition. It's terrific news. Glad that you're here. Good morning.
Good morning. Can you hear me, Mark?
I can hear and see you.
Nice to be with you all. Morning.
Happy you're here. I hope that Chief Kenny doesn't mind me just putting a bit of a quick spotlight on him. Luckily, we have a bit of time to brace ourselves for the news, but you know, I've gotten to know Chief Kenny since my very first CJPAC meeting, and as a longtime Central Connecticut resident, certainly familiar with his town of Vernon and the incredible work he's done leading that department over the years. The chief indicated that in the coming months he would be taking a well-deserved step into retirement, and we've had other members of our commission that move, and luckily we still have a little bit more time with the chief before he takes that next step in his life. But it's always bittersweet where we appreciate the impact on public service, public safety that the individuals who serve in this commission have, and the impact that they bring to our discussions here. And I've always benefited from the chief's input on public safety, on crime and arrest, on front end trends, and as the chief has updated us on the role of the department and some of the vaccine sites in his town, and just the array of issues, I think that law enforcement executives provide such powerful insights into a range of issues affecting our state at the very front end, which have implications that ripple all the way through the criminal justice system in our efforts to improve public safety, use resources more effectively, and strengthen communities across our state. So, Chief, just thank you so much for all the years of service that you brought to this commission, and I just want to congratulate you on your service and say we're grateful for the time we have to continue working with you. But I'm personally happy for you personally. I think you well deserved. So.
Oh, thank you very much. It's been a long career, 40 years total in uniform in various departments in the military. Not that I'm counting, but I have 106 days, 2 hours, 44 minutes, and 1 second. But I got a little calculator here on my phone to tell me exactly. So I plan on working to the end. I've already indicated to Chief Stewart to get a suitable replacement for me here on the committee, and I look forward to working for the last couple of meetings with everyone on the committee. I've been here since 2008, and it seems like just yesterday. So, but thank you very much, sir.
Thank you, sir. Indeed, thank you. I talked to Chief Stewart as well, the president of the Connecticut Police Chiefs Association. Just, I wanted to be sure that as he contemplates a chief to fill your seat, sir, that we get someone of comparable stature. And he assured me that we would. And so I just shared with him just how grateful we were for your years of service on the commission and the impact that your insights brought. You cannot manufacture 40 plus years of law enforcement service. And so that experience has really informed our work. And so the chief and I'll be of assistance to him however I can in those discussions, Chief Stewart, I mean, but we are thrilled to have a couple more meetings with you, we hope. And I might ask you next month for an update on your calculator clock to see how it's coming along.
I found it on the app site, so it was used by my wife to no end. So
I bet.
But thank you very much, sir.
My pleasure. Very good. Well, I distributed the draft minutes from the February 25th meeting. I wondered if anyone had any questions or feedback or comments on the document. I wonder if I could ask for just a motion to approve the minutes.
So moved.
Oh, thank you, Ms. Nolan. May I ask for a second, please?
Second.
I think that was Ms. Rapillo.
Oh, I'm sorry. Thank you, Attorney Rapillo. And a lot of competition for the second. I think I'll go with Director Begg if it's okay. I don't know if I've awarded him the first or second in recent times. So I think what's the opening tip goes to the director. Speaking of which, we have a very exciting UConn basketball season for the women to keep watching. So it's moving fast. The Sweet 16 is where they've reached now. So let's keep cheering them on for the rest of the way. So we'll turn now to, with that approved, turn to the monthly indicators report for the month of March, which I believe I shared the final draft yesterday. And if I could turn to you, Kyle, our Statistical Analysis Center Director, perhaps to share his screen and to introduce the indicators. I think you'll be homing in on the arrest data that's in there. And please, as he's going through it, use your virtual hand raise or come off mute and be happy to engage any questions you may have. Kyle, if you're able to, the floor is yours.
Good morning, Mark and the commission. I began sharing my screen, which includes a PowerPoint. Would you just confirm that it's being displayed to the rest of the commission?
Yes, sir. I can see you and the slide. So, you did great. Well done.
I'm going to do a quick overview just as a check-in on where we are in March, both with our monthly indicators, prison population forecast, and then cover a new arrest methodology that we began incorporating into the monthly indicators report this month after a brief hiatus where we didn't report on arrest data for a few months. So I think just a good opportunity. Well, thought I was going to proceed through the slides, but I was wrong. We'll start with the prison population forecast discussion. This section, and I'm not going to display the entire document to the group, but I think it was circulated and it's also available on our website. It appears on page 1. It's on the right-hand side. It's chart 1 and table 1 of our monthly indicators report. And in this case, this is the chart 1, which displays last year's prison population in addition to our forecast for last year's prison population. And then with the dotted vertical line starts where we are currently looking forward with our prison population forecast for the current year. Just the quick sort of temperature taking right now is we're holding steady with what we predicted 1 month into our prison population forecast, which is not all that uncommon. If you look at last year on the left-hand side of the chart displayed, we were pretty close in making an estimate 1 month out from when we started in February of 2020. Things went a little bit sideways from there, as we all know, and a lot can change over the months that proceed from the day we release our forecast. And it's just important to remember that the uncertainty grows month over month as we progress through the forecast year. But good harbinger so far, we're only about 25 inmates off of what was forecast. And the overall pattern that we're tracking right now is a very slow, gradual decline from where we started off at the beginning of sort of our forecast year, which is February. But at some point, that we expect that to change as both society at large and processes in the criminal justice system begin to change and pick up some pace. We expect people to be admitted to in larger volumes to the prison system at some point in the year. The timing of which is very difficult to ascertain because it's not only dependent on internal factors to the system, but also external societal factors for which we don't have really good models or good data to support. But what we are doing in an effort to sort of provide some foresight to when this change will happen or when we might see some deviation from our current gradual descending population, or we're tracking metrics. We're tracking the inputs and the outputs of the criminal justice system. And one of the big front end indicators that we keep an eye on is the monthly arrest totals, which is what we're covering in chart 2A this month, as a way to reintroduce our arrest data into the monthly indicators report, and to provide that front end indicator, sort of the raw volume of people being introduced into the criminal justice system or reintroduced in many cases, and having their cases be disposed or adjudicated in the court system. I just want to give, so this is what chart 2A looks like this month, and this is the metric we'll be tracking going forward for arrests in that front end volume. And if we see this tick up, and we also see pretrial admissions to the DOC tick up, and we also see new sentence admits begin to increase, those are the things we're looking for to sort of give us some lead time on a reversal of our current trend. But shifting gears back to the chart that's in front of us, what we have are we have a stacked bar chart that covers the years 2016 through the early part of 2021, and it's the monthly sum of new criminal cases added in the court system, both on the criminal docket in the dark blue and on the motor vehicle docket in the light blue. Just to give some background on how we've calculated or reported on arrest data in our monthly indicators report in the past is we receive a file from CJPAC every month, which is a rolled up aggregated version of the judicial branch's CRMVS data system. And what we've been counting are new cases added to the criminal docket. We get actually 4 categories from CJPAC. We get the criminal new cases added to the criminal docket, new cases added to the motor vehicle docket, new cases added to the motor vehicle infractions, and new cases added to criminal infractions. And historically, we only included new criminal cases on that criminal docket as our arrest metric for the statewide arrests in Connecticut. We do systematically and routinely review the data elements that we include in the monthly indicators report, and we did so late last year. And in conversation with CJIS as well, and really importantly is the judicial branch and Joe Grealish there, we learned more about what the data represents. And we realized that we were, while the trend analysis and the historical comparison holds that the data is reliable, a more accurate measure of the front end arrest metric would also include that motor vehicle docket, because cases added that motor vehicle docket also have the potential to result in a term of incarceration. And so to more fully capture that front end metric, we thought we should include both of those subcategories of docket types. So what you'll see is something very similar in terms of a trend or a relationship to historical arrest figures, but the numbers will be slightly higher, in some cases considerably higher than what we reported on previously in the monthly indicators. And so I just wanted to represent those two docket types and that monthly totals in a chart in chart 2A to demonstrate both the strong relationship between the two. You see they follow a very, very similar pattern. Although COVID back in April of 2020 did disrupt the motor vehicle cases more significantly than the criminal cases. So there's a lot going into that. But this is a metric we're going to track going forward as we assume a return to some degree of normalcy following the global public health crisis we've been experiencing over the last year now. It's really it was this meeting about a year ago that we really began discussing COVID and its impact on the criminal justice system. I don't see any hands raised. I was really just going to cover these two topics rather briskly because then we have some other conversations to have today. But I'm open to any questions or any comments that people may have about our new methodology or any questions. Thank you, Mark.
Thank you, Kyle. And actually, it's funny that you should raise where we were a year ago. I actually remember that sitting in the LOV and going around and providing updates. And I remember vividly Commissioner Ravella raising the response. And that was either in February or March. I suspect it was February, where he mentioned the intensive work that was being done to study and learn, gather information, and prepare. And I remember others began asking questions. So we were, my hunch is February, and I can check, but that really puts into perspective the time that has passed. And I think this data, again, is just crucial to be updated. And I'm glad we pressed pause on including it in our monthly until we could update the methodology. And I see Commissioner Quiros' hand is up, so I'm going to call on him in just a moment, but would like just to call out to the judicial branch or CJIS if they would care to share any additional insights. I think Kylie did a great job of covering the work that was done, but I know we're always eager for their insights as well as others. Commissioner Quiros, the floor is yours, sir.
Thank you, Mark. Thank you, Kyle. No real questions, just a comment. This information is critical for me, Kyle. As you know, I'm faced with 3 facility closures. The first 2 will be pretty simple for me because I have the bed space, but as the population starts picking up, the arrest starts picking up, and sentencing starts picking up, I'm relying so heavily on this information on where do I go for that 3rd facility, to close that 3rd facility. So just thank you for the information, and if you see any trends out there that I need to be aware of that's going to drive our population up, please share with me, and thank you for your work.
Absolutely, Commissioner. This was a really high level review of the information that we have. We can also work with some people within your team. I hate to throw people's names out there, but Steve Lamphere is one guy I really enjoy working with at the DOC. If we wanted to dig into some more nuanced information, more granular information about the population, and if you wanted to make an assessment about facility closures down the road and what that might look like, I know you guys have it well underhand, but we're always here to help, sir.
I appreciate your help, though, and I'll probably take you up on that. Thank you.
Yes, sir.
Commissioner, I appreciate your question, and Kyle for your reaction. And something that occurred to me also to share is that this improvement is one step of a larger set that we want to explore. We also would like to really beef up our front end data collection. and reporting in the monthly, and it'll take a bit more time to get there, but with our partnerships with the judicial branch, we're confident we'll get there. We want to perhaps enhance the information about kind of pretrial decision-making, use of jail re-interview, perhaps treatment pathways and other areas. I think that during the initial months of COVID, when the same desire the commissioner mentioned, I heard across the system, is wanting to know about impacts on the front end. And I think we emphasized, Kyle, pretty heavily this arrest information as well as pretrial admissions into the DOC. And we sought out other information for like open data portal to get some Hartford PD information. But I think that what the commissioner is interested in, we are as well. And whether it's ad hoc basis inclusion or ideally incorporation into the monthly, we recognize that these front end data are so important for informing a variety of policies and practices that affect corrections, pretrial, law enforcement, communities. I think also about the discussion we had just 2 months ago with Dr. Norco regarding people with mental health needs entering the criminal justice system and strategies for front-end diversion. That touches on it too. It just reinforces for me these front-end options are very powerful and necessary. So, not sure, Kyle, if you have anything you would care to elaborate a bit more on regarding the additional improvements we're seeking to the monthly. But I want to give you the platform if you wanted to.
Well, thanks, Mark. Yes, it's included in the highlights section. We did do a brief write-up about our intentionality to increase our reporting on front-end metrics. The monthly indicators is really a high-level 10,000-foot view document, but we think it's important to improve our model, particularly as it relates to front-end processes and the diversion that happens between the different decision points in the criminal justice process, between arrest and then also between that ultimate pretrial admission and then a term of incarceration. And we know that that CSSD does a lot of work to divert people from that arrest stage to the admission into the Department of Correction stage, and we don't really offer a lot of information in our model currently about those processes. And we had some conversations back in January with Brian Sperry and with Mike Hines about what sort of metrics would be appropriate for the monthly indicators report and provide the most information. Those conversations are ongoing. I'm sure everyone knows I have a newborn at home, and we've been through a lot, and that delayed some of those conversations. I will use her as an excuse as long as I possibly can for why things might get delayed, as long as people will accept it. But it's a conversation we're going to be picking up in the coming weeks and months with folks over at CSSD.
Thanks, Kyle. Perfect segue, perhaps. I see Director Roberge's hand is raised. Sir, the floor is yours.
Thank you, Mr. Chair. I just wanted to say thanks for working with the branch on modifying Chart 2A here. I think it's important, as you and Kyle have both noted, right, that there are it's not a significant percentage, but there's a good percentage of cases that do end up affecting the DOC population that come out of the motor vehicle arrest. So to just make it as accurate as possible, which I know you guys try to do on the monthly indicator reports. And really, along the conversation, as CRMVS, and Joe Grealish knows that information, like you all have been saying, better than anybody in the branch. So to get his input on this, I think was really important. And to Kyle's point, as CRMVS and Joe's data and our CMIS data and CSSD becomes more robust and can inform the data we look at every month and the decisions that we have to make as we try to understand the system better and to get better outcomes, I think is just going to benefit everybody. So thanks for taking the time to pull back on this particular chart and to make the modifications to it. And we'll continue to do that as we obtain more data and better data to inform our decisions. So thank you, Mr. Chair.
My pleasure, sir. And just to kind of round out the partnership that worked on this, Director Begg, love to hear from you, sir.
Yes, thank you, Mr. Chair. I just wanted to make sure that I acknowledge the people at CJS who worked on this as well. There's John Blowell, who's not on, but I do believe Pat DeMichelle is on. I mean, we are always eager to help other agencies. We collect a lot of data. A lot of data passes through CJIS to different agencies. So it's a great repository that, people like Kyle, who are great analysts and can have an insight into some of this data. And we can pull out all kinds of information to be able to predict or to create charts where you can look at trends. So I'm happy to cooperate and work with all the different agencies. And if there's anybody else who wants to, use the data, we'd be happy to provide that.
Thank you, sir. And while we're speaking, I did want to just remind either myself, sometimes it helps for me to say things so I don't forget them, is that we had discussed, Director Begg, with arranging for a CJIS presentation at a CJPAC meeting before our break this summer, recognizing the significant kind of rollout that has happened with CJIS from the CIS entering phase 2. Deployment to a significant increase in practitioners in the criminal justice system, with the beginning of the electronic workflow of arrest records from police departments to courthouses in certain parts of our state, with the go live of the e-prosecutor system. The CJIS is involved in those and many more. I'm sure I'm just scratching the surface of these projects. So we had talked about arranging time for a update on the various technology and resources that are being disseminated. And I'd like to follow up with you before the next meeting just to see what might be a good date from your vantage point. Because I think many members of the commission would be very interested in the data and what's available.
Absolutely, and it'll be a great opportunity for us to highlight where CJIS is fitting in to bring Connecticut criminal justice into a more of an electronic workflow process versus the manual process that's been going on.
Yes, sir. Very good. No, I could not agree more. Great. Well, thanks, Kyle, very much for the monthly update and the presentation. Are there any additional questions that anyone on the commission or attending the meeting might have? Well, great. Well, I'll pivot now to the presentation topic. And this is an idea brought to my attention by Attorney Rapillo and Director Roberge Director Sparacco, with a update on the implementation of a specialized unit within the Division of Parole, within the Division of Public Defender Services to provide representation to people at parole violation hearings. And so I will be giving a quick overview and of the work, and then I'll be turning in after my intro to Attorney Rapillo and then Director Sparacco to introduce members of their agencies who are here to provide us with an update. We have not only probably broad vision perspective from the presenters, we also have experiences to date with implementing this novel approach from the practitioners in the board and the division who have been implementing this. We have data, which is going to be great, from both shops about impacts to date. And I think we could then conclude with discussion and then a vision forward for how to evolve this pilot into any additional elements. I did invite Fiona Doherty, who is the clinical professor of law at Yale Law School, and I didn't give too much notice, so I don't want to put her too much on the spot, so I'll just warm up the floor a bit and then invite her if she wishes to elaborate a bit more on the topic. But the Yale Law School published 3 years ago, Parole Revocation in Connecticut, Opportunities to Reduce Incarceration report that lays out the work that began in 2015 to examine the parole violation hearing process. And Yale Law School stepped in to assist in convenings with the agencies I've already mentioned, in the DOC and others, and to deploy students to observe parole violation hearings, and to also conduct survey interviews with people at parole violation hearings to collect quantitative and qualitative information to bring back to make recommendations. And so the work that Yale assisted the state of Connecticut with from 2015 through, I think all the way up until really through 2018, informed a policy that was included in, which is now Public Act 1959, to create this pilot. and to require reporting of data from it. So I just wanted to invite Professor Doherty, if she would wish to at this point, just to share any insights regarding what I gave a pretty broad overview of on the topic, if she wishes now, or it'd be great to allow her that space.
Hello, everyone. Can you hear me?
Loud and clear,
Okay,
ma'am. Good morning.
okay, good. It's so nice to see so many familiar faces. It's been a while since we've been engaged in this work, and I'm really excited to hear about all the progress that has been made. And maybe I should just say a couple words about what initiated this. This was really part of Governor Malloy's Second Chance Society initiative. So we work closely with Mike Lawler and Eleanor Michael, Rich Sparacco. I see Eric Ellison. I see Carlton Giles. I see so many people that we collaborated with incredibly closely. And really the genesis of our study was to understand why so many people were being sent back to prison on parole revocation hearings, really just to observe, to talk to people, to understand. And out of our study, we really, like nobody had appointed counsel at that time. So I can't, like, just the progress on that front, and Attorney Rapillo's office and the leadership role that they've had. I can't wait to hear about the fruits of those efforts, but nobody at that time had appointed counsel. There was 100% revocation rate, and people really couldn't, because they were all detained, present mitigating evidence or contest facts. So that led to a whole series of recommendations and close collaboration with the parole board and with DOC, many conversations. And part of the reform initiative was to try to get counsel for people who were in parole revocation proceedings. And that's kind of how we ended up where we are today. And Attorney Rapillo's office and Lisa Villa have been incredible forces in that effort. So I'm just delighted to be a guest, delighted to see all of you here today, and I'm very much looking forward to hearing about the continued progress.
Thank you, Professor. This is Mark, and as someone who's tried to facilitate this commission through the virtual period, it is so nice to have a guest of your stature here for both your expertise in this area, but also just the kind of friendly nature you bring, and just the welcoming and outreach to so many people. We try so hard each month to really use relationships and desire for continual system improvement to work with one another to improve outcomes. And I really admire the way that Yale worked on this, your students and you and other faculty members, that you worked within the systems to understand and really map out and model the parole violation hearing process. My coworker just placed into the chat for CJPAC the Yale Law School report that was issued, and it's such a helpful document because it brings voice to the surveys that you conducted. It provides student observations of the hearing process, and it really maps out the flow of cases. It's a really helpful way both to learn about the effort and to understand the parole violation hearing process at the time of publication of the report. So thank you. Attorney Rapillo, I think I'll turn to you to invite you to provide an overview, introduce your team who is here. Fiona mentioned Attorney Villa, and perhaps others are here too. I would love to hear a bit from you about it, and then we can turn to Rich Baracco.
Sure. I mean, just by way of big picture overview, I mean, it had been known for a long time that folks did not have counsel in parole revocation hearings. It wasn't something that was provided for in the enabling statutes for our office, and definitely not something that we were funded for. So we had been approached, I think when the report first came out, by Mike Lawler to talk about it. That was, we were still in the middle of dealing with layoffs and budget cuts, and we just didn't have any really legal authority or capacity within the agency to add something like this. I mean, in order to do it, you really want to be able to offer it to just about everybody. To be picking and choosing people to get representation ends up being problematic for lots of different reasons. So, we were excited. I remember being approached by Mark that this was something that Governor Lamont wanted to dip his toe in as he was exploring sort of what his criminal justice packages were going to look like. And we had lots of conversations about it. I will say we were a little trepidatious at first because to take something on, we were still rebuilding after pretty devastating layoffs. And we were concerned that taking something on, sort of as a permanent fixture, where we were still worried about budget cuts, that it would negatively impact all the other things that we did. And if we were going to do it, we wanted to be able to do it well. So, we had lots of negotiations. We were asked to submit, what would you need to get this up and running? And we decided to be reasonable because, of course, I could have, like anything, you could make anything cost $2 million if you really want to. But we tried to be really thoughtful. We met with Professor Doherty and her folks to kind of talk about, what would be needed. And I know that what we got wasn't everything that everybody wanted to be able to serve these folks. But what we landed on was we ended up getting funding for a pilot project, so that if we had budget issues, we would be able to modify what we did. But it was our statutory authority was expanded to provide representation for folks in parole revocation hearings. We were giving funding, and then we were giving the autonomy to set the unit up as we saw fit. So we decided to hire 2 attorneys. There's a clerical position, and rather than adding an additional attorney or an investigator, we put a social worker in there. Because we were hoping that would be able to, people who are coming in on a violation, there's a problem somewhere. So having social work support, we believed would be the right approach and consistent with what we do as an agency to try to provide holistic representation to folks. So the Public Act was passed, and we kind of immediately started working on this. Prior to the passage of the act, we began working with Director Sparacco and started to talk to corrections. And I know that in the beginning, people were like, oh God, lawyers. Which is, of course, everybody's reaction. Why would you want to add a lawyer into a system that we think is working, pretty much fine without all of you? But I have to say, we were so impressed with everybody's openness to work with us, openness to, even the parole officers who really, now you're introducing an attorney who's going to question what you did. But people approached it, really with, I think, an aura of collegiality and an acknowledgement that probably 100% revocation rate was something that we wanted to look to change, and that if we have fewer people in prison and make sure everything was being done safely and justly and with due process, that was better for everybody. So we worked with Rich Sparacco, we worked with Eric Ellison and with their folks to kind of figure out how this was all going to go. And in the meantime, as I said, we were able to put 2 experienced attorneys into these positions. As luck would have it for us, the judicial branch decided to shut down the Bristol court at the same time that we were launching this. So we were able to, and Attorney Lisa Villa, who was the supervisor in Bristol, is just a public defender with vast experience. She's been with the agency a number of years, but she's done a lot of things. And she's always been very committed to the clients and very committed to a fair process. So we were lucky enough to be able to move her in to lead the new parole revocation unit. And Attorney Alphonse Sirica came with her, and their clerical individual also. We had kind of a cohesive unit that we were able to move into this position right away. So we didn't have people needing to get to know each other. They were able to get in and kind of launch. And I don't want to, Lisa then took it over and did, much of the implementation work with the folks at the board and the folks at PCS. So I don't want to steal her thunder and let her talk about all the good work she did. But it was quite a process to, we had to work with the board, with corrections, and with our people to kind of let our field people know that this is something new that we were doing and that there was an expectation across the agency that people were going to help us make this successful by targeting people as they came into court. We feel like it's been successful, so we've got some data. I think, Mark, so that's kind of the 360 overview of how we approached it, of where we went. And then I'll kind of stop and, maybe Rich and Director Ellison can let you know whether it was all as friendly and fun as I'm making it sound, but I think it really was.
That's so helpful. I believe so. It'd be great to hear from Rich Sparacco, if it's possible. Perhaps he can introduce his team that is here and provide perhaps a 360-degree overview, and then I invite Director Ellison as well. And then perhaps we could turn to Attorney Villa's presentation. I'd be happy to share my screen and allow the attorney to go through her findings. But Director Sparacco, why don't I turn? Thank you, ma'am. Director Sparacco, can I turn to you? If you want to, I think Supervisor Garibaldi is here as well from the board and perhaps others.
Yeah, sure. Chris stated it perfectly when she said we all work together, because that's really was the key to all of this, is that collaboration and communication. You know, I do want to thank, you know, Fiona and Yale early on when, you know, started working on this report and, you know, brought to light certain things about the violation process. And our goal was, you know, when the chair was appointed and when he appointed me, was to take a good hard look at some of our processes and make sure that, you know, we were offering these processes to the best of our abilities, that they were professional, they were consistent. And, you know, so the violation hearings, you know, when we first started looking at them, we said, you know, I think there's definitely room for improvement. As the chair says many times, the biggest room is the room for change. You know, so we took a hard look at the process, and I think, you know, we worked with Yale, we worked with Parole and Community Services, the Department of Correction, and then ultimately we worked with the public defenders, and that's you know, the reason why we're here today. Yeah, I think we have a much better, consistent process now. I think adding the public defenders added structure and created a much more professional process. You know, when this law was passed, we began working right away. It was good that they were placed right in the same building that we work out in Waterbury, so they're one floor below us. So, you know, even though the law became effective on July 1st of 2019, you know, we expected representation was going to officially start in October. So we started meetings. We reached out. It was very easy to beginning to start the collaboration. We also, after that, decided that we needed a little bit more extensive training for our hearing examiners and our board. We revised our policy for revocations effective January 1st of 2020. And we shared that, and we worked collaboratively with Parole and Community Services about some of those changes. And I think one of the first things that, you know, we worked with public defenders was changing our notice. You know, putting out there to parolees who are being remanded back that they now have the option of representation. So I think, you know, even before they started official representation, we started to work together, change some forms. We added appearance forms, continuation forms, notice of parolee rights, preliminary hearing forms, and waiver forms, all to our website. And I think going through all this, you know, we provided a lot more clarity, some expediency. There's better information for the parolees that are provided by the public defenders, better information that's even provided for our hearing examiners and even the parole officers from Parole and Community Services who are attending the hearings, because they have some additional information that we're not aware of that's going on in the courts, you know, even for criminal violations. So I think the process has just only improved, and I think it's attributed to the collaboration that we've had through all this. And I think, you know, and Mark, you've mentioned this many times, that, you know, we're a small state, and I think it's because who we are and we can be around a table like this that we can accomplish, you know, things such as, what we did with the violation process and, you know, introduction of public defenders into in the process as well. So I'm not going to steal the thunder either from my team. On board today, I have Joe Garibaldi, who's our parole supervisor. He's the one who oversees the revocation and rescission unit and really had to work operationally with how we were going to notify, you know, exchange information and have public defenders appear at our hearings. Also on board with me today is also my research unit, my associate research analyst, Vilmaris Diaz, and research analyst, Lee Floody. So they're going to do a little presentation afterwards, just basically about a lot of numbers and what we've seen, and we'll go from there. So without any further ado, I'll turn it back to you, Mark.
Thank you, sir. I appreciate that. I'll turn to Director Ellison, if you would wish to speak, or anyone from the DOC for, again, a 360-degree overview. After that, I'll just see if there are any initial questions before I'll turn to Attorney Vila. And I do have her presentation up, and I'll be ready to share my screen once she gives me the green light. Director Ellison or anyone from the DOC, would you care to speak?
I would, Mark, or I'll certainly defer to anyone from DOC if they.
Oh.
If not, I thank you.
Go ahead, Eric.
Thank you, Commissioner. Good morning, everyone. It's good to see Professor Doherty and Attorney Rapillo. Thank you, and Rich. Thank you. This was a collaborative effort. We did welcome this, and I applaud the work that's been done. And we saw this as complementing the work that we began really very deliberately in 2016 to reduce technical violations with our with the award that we received through the statewide recidivism reduction grant from the Bureau of Justice Assistance. It complemented so well the evidence-based practices that we adopted, and having public defenders involved in the process, I believe, and I've said it many times, brings integrity, fairness to the process. I think fairness and credibility are so important for the population that we supervise. It made our staff better parole officers as well, to ensure that we're adhering to statutory requirements and ensuring that we've met probable cause standards. And I'm so proud of our staff for the work that they've done. We've been working for many years now to change the culture and to really have a balanced approach to supervision. We believe our use of graduated sanctions, graduated interventions has increased. I think we're seeing results from that year after year with our reduced technical violations. I was just reviewing a press release that the DOC Director Martucci's office released last year during Parole and Probation Week, and it referenced the total number of violations that we administered in 2012 was over 1,200, and in 2020 it was 290. So we've made, as a system, significant reductions in violations, and we continue to do that through our work with evidence-based practices in the community. For example, we've trained our parole officers in cognitive behavioral therapy techniques, effective practices in community supervision, so we can provide interventions at very critical points during the supervision process. We saw our parole officers' commitment to interventions, graduated interventions, especially during the pandemic, when they were driving by correctional facilities, when they would drive by a jail and drive the person another 50 miles to an inpatient drug program. So that's the kind of change in the culture that we've seen and that we're promoting. It certainly would not have happened without the commissioner's support and our deputy commissioners. Really, the foundation is human dignity, and we're glad to be part of the process and always looking for opportunities to improve our work. It prompted us to do trainings as well, to adopt quality assurance, so we can be sure that our parole officers are administering risk assessments accurately, so the individuals we supervise can be supervised at appropriate levels. We can manage our resources well, and not over supervise and supervise those that pose a risk to the community or a risk to themselves. So thank you very much, and I look forward to the presentation.
Thank you, Director. Appreciate it. Attorney Vila, I know that you're a guest, and certainly teams can be a little unorthodox in large groups. Are you able to turn on your video and say a quick hello, ma'am?
Yes, but I think my video is on.
Oh, very good. Yeah, Teams is funny. It relegates some people to the lower row, and I miss them. But
yeah,
I can go ahead and share my screen and bring up your presentation now if you'd like.
yes, thank you.
Very good. I hope that everyone can see it now. The main slide. Right. Are you able to?
Mark, thank you.
Very good. Very good. I'll go ahead and get started here with a allowance for a bit of background.
So Lisa, I can just do this really quickly. I mean, this is what I spoke of a minute ago, just some of the background on it, that there had been an interest in doing this program for quite a while. Finally, you know, Governor Lamont made it a priority, and this is just a little bit of information that I had gone over about, you know, how we got started and what our resources were to get it started.
Very good. Very good. Thank you. And you mentioned this as well, I think, Chief Rapillo, about and I think that's an interesting feature that the Board of Pardons has a single office space in Waterbury, and that is also where this unit is co-located, a few floors up or down. And the fact that you included in your staffing a social worker, which I think was a real positive attribute for working with the clients to prepare the information for the hearings and address other factors.
Well, I mean, one of the decisions we had to make was, in order to serve the most number of people, how are we going to be most efficient with the funding that we had and utilizing our field staff? So, you know, we have investigators in all of our field offices. So with the new arrest violations that come in, they're responsible for doing the investigative work on those cases and for making sure that the information gets relayed to our parole revocation unit. So the social workers assigned to the field offices wouldn't be working with folks who came in on technical violations, who for the most part are going to be people who maybe need some discussion about what program they need, additional mental health, some support we can provide to parole, some assistance we can provide to parole in trying to figure out what the appropriate programming for that person is that can safely get them back into the community. So that was how we decided to try to utilize as much staff as we could and maximize our resources to get this going. The office space was a real challenge. Now, where do you there's just not space anywhere. There's nowhere in a courthouse to locate anybody. Everyone's maxed out. And so as serendipity would have it, our appellate unit, our legal services unit, is located in the same building as the Board of Pardons and Paroles, and we were able to carve out some space there for Attorney Villa and her staff. And it's worked out extremely well.
Glad to hear that. It would seem, especially for setting up a unit of this nature, if we were to give advice to other states, it would be seeking the experienced attorneys because of the because of, I guess, how novel this approach really is, that it is something different than the current approach. So you want to have that that experience embedded.
You definitely needed somebody who was already very familiar with how the system worked. You know, with the funding, we thought we would have to hire entry-level folks to do this and have it supervised in some other way, either out of the chief's office. But just because of the way things worked out with the Bristol courthouse closing, you know, we were able to get two people who knew what they were doing, who understood about negotiations, who were extremely committed to, you know, due process and fairness to the clients. And I think this would not have worked out as well had we not done it this way and put experienced people in there. And then, you know, you've just got to be creative with how you get buy-in from the rest of the agency. It's not just the parole unit. This is a project of the Division of Public Defender Services and the messaging. And that is one of the challenges that we continue to work on, but that it's everybody's job now to spot these cases and to make sure the information gets to the unit so that they can then share things with the board or with Parole Community Services in order to, you know, best serve these clients.
That's really helpful insight. The next slide is, I think, really helpful, that drills into some of the preliminary organizational activity. This is really helpful information here. I think either you, Chris, or Lisa, would be great to hear some insights.
I'm going to turn this over to Lisa, because although we worked together on this, she was really responsible for setting this up and for getting all of the kind of preliminary implementation work done. So Lisa, you want to take it away?
Sure. Thank you, Chris. So the initial thing we had to do was advertise our existence effectively. And so we did develop certain protocols for our public defender field offices and the courthouses in order to make sure that we were getting referrals from them for clients that were coming in on parole or special parole remands. So we had to develop some documents and protocol there, which so far I would point out has been successful to a degree, but given some of the challenges with the pandemic and just general challenging situations, we're not quite up to speed with regard to the implementation of these protocols with the field offices. So we're still working on that. Some of the field offices are very good about following the protocols, and some of the offices are not on top of it yet. The next line down, we worked extensively with the Board of Pardons and Paroles and the PCS, Parole and Community Services, to create the process for notice to parolees and for eligibility applications. And I would like to take this moment to thank Rich Sparacco and his folks, and Eric Ellison and his folks. They've been excellent mentors. They've been very cooperative and helpful. This was quite a big learning curve, even though I'm an experienced attorney. As Chris pointed out, I've been around for a million years. This was a new process for me, and so there was a learning curve. And Eric and Rich were very, very helpful with regard to working with my unit to educate us and to help us along in our implementation of our program, basically to be as efficient and fair as possible. Next, We did have to address hearing schedule issues and access to DOC counselors during this beginning phase. It's just an organizational situation that we had to address. The next two items, I needed to develop the social workers and our administrative assistants responsibilities. I will tell you the social worker has been extremely important to our functioning, and I think the Board of Pardons and Paroles review panel appreciates our work. We have our social worker, basically she submits a little report, a biographical report to the Board of Pardons and Paroles about our clients for their final revocation hearings. And it highlights good information about the client in terms of family background, education, employment, mental health situations, substance abuse, just a lot of biographical outline, but it does highlight all the good things the person has done while on parole, and then the second half of the report highlights all the good plans that person has upon reinstatement on parole. We've submitted these reports for every single client that ends up with a final revocation hearing. And my understanding is, anecdotally, that the board is happy to have this additional information. We've also developed, with regard to my secretary, in this unit, the secretary has a labor-intensive job. She does a lot of various things. She has duties regarding notice, responding to clients, scheduling issues, all kinds of things that we've developed to make our unit as efficient as possible and as transparent as possible for our clients. And we were asked to indicate, our first client intake occurred on September 17th, 2019. And I would point out we had a very slow start, primarily because nobody knew we existed yet. So during the next, I would say 2 to 3 months, things were slow as we got going. But after I would say about 3 months, things started picking up in terms of the number of referrals we were receiving. And that's in part because our field officers were notifying clients of our existence, and the Board of Pardons and Paroles and PCS had changed their notification process, and DOC was involved too. The DOC counselors were advised of our existence, and we're also notifying incoming inmates of our existence. So all of those issues helped get us going. We also, at the beginning stages, drafted various form letters and notices to be sent to our new clients. This was part of the effort to become as efficient as possible, and also to make sure that our clients had as much information as possible so they understood what the process was and what to expect going forward, and who to contact for various issues or reasons. We also met with the Board of Pardons and Paroles, Rich Baracco, his folks, very regularly, as Rich mentioned, for the first, I'd say, 3 or 4 months. And these were mostly educational meetings from my point of view, but we reviewed certain aspects of the parole revocation process, and coming in with fresh eyes, I was looking at ways that the existence of the parole revocation unit that's listed as PRU there on the screen, how our existence could affect some efficiencies within the Board of Pardons and Paroles parole revocation processes. So that's what we did at the beginning.
This is Mark again. Thank you very much. That's so helpful, and something that I think will be picked up as a thread when the board and PCS weigh in again later, is the fact that this unit provided greater perhaps standardization, professionalization, consistency in responding. I'm thinking about the board having decision makers, hearing examiners being provided with more complete and prepared information at the hearing. I'm thinking about public defenders at courthouses around the state in their service to defendants who may be on parole, and knowing what options are available. And I'm thinking about the PCS level too. It seems that a small but mighty unit had some pretty helpful cross-system benefits. Perhaps here for the attorney is some data you pulled together. This is helpful to see just the number of cases and clients.
Yes, and the total cases is 545, total clients is 428. So we did have some repeat customers, and that's why the total clients is a lower number. And the number of revocations hearings is 370. That's lower than the number of preliminary hearings, and that's because certain preliminary hearings don't go any further than the preliminary hearing. And sometimes people discharge off their sentence before ever getting to a revocation hearing. So that's the reasons for the discrepancy in those numbers. And then the Board of Pardons and Parole's final review hearings are the hearings after the final revocations hearings, where they review the recommendations of the hearing examiner. So those are the numbers that we have at this point.
That's helpful. And so for everyone's understanding, the preliminary hearings are held a certain number of days after the person has been presented with the violation, and then the next step, if it proceeds, is a revocation hearing, and then a final review. Is that roughly correct, or would you mind perhaps elaborating?
Yes, I'm sorry. The preliminary hearings are basically their probable cause hearings, similar to those that would occur on the court side. So it's simply a hearing to determine whether or not there is probable cause for one or more violations of parole. And it's a highly technical hearing in nature, in the sense that we're reviewing, the defense counsel is reviewing the evidence that's been submitted by the parole officers to determine whether or not there's sufficient evidence for a probable cause finding for an alleged violation. And frequently there isn't. I will tell you, when we started this program, the parole officers had not been as, I guess, educated with regard to evidence as possibly as much as they could be. And with the introduction of our unit, as Rich Sparacco mentioned, they did some additional training for parole officers, and it's been noticeable from our point of view, that the parole officers now are submitting evidence that is much more in line with what they need to submit for probable cause determinations. So that's a bad thing in one sense for us, because previously we could shoot down these probable cause findings relatively easier. Now it's a little more challenging. We have to look a little harder for problems. But I will say it's the parole officers, by and large, are much more professional about what they're submitting in terms of evidence, and as a result, there's fewer no findings of probable cause at these preliminary hearings. And then going on to the final revocations hearings are hearings that are held, they have to be held within 60 days of the preliminary hearing, unless there's outstanding criminal charges or some other issue that's preventing the hearing from being scheduled. And those final revocation hearings, again, we go through the evidence from the beginning to end to determine whether, by a preponderance of the evidence, the hearing examiner can make a finding of a parole violation. So although there's a review of the evidence at the preliminary hearing, the final revocation hearing is what actually counts in terms of determinations of whether there is a violation or not. And regularly there are changes that where there's a finding at the preliminary hearing and then there isn't a finding at the revocation hearing level. So and I think it does make a difference in my experience to have an attorney present at these preliminary hearings and at the revocation hearings, because in my experience, watching the unrepresented inmates, they go into these preliminary hearings and revocation hearings apologizing and admitting everything that's been alleged. So they don't understand that it's an adversarial process. So it's been my experience that our existence, having an attorney, is very helpful for clients in terms of understanding the process and protecting their legal rights. and getting them reinstated, getting them through the process as unscathed as possible. And the social workers' existence and the social workers' work in this regard is very helpful with that.
Mark, if I could just jump in for a second, Professor Doherty pointed out that very, very few people had counsel prior to this program. So this is, 500 people who wouldn't have had attorneys otherwise, who now do. So it's really a sea change in how the process goes. And this idea that people have an attorney to shepherd them through the process, helps with this whole concept of procedural justice, that if you have somebody who feels like they had some assistance and that they got treated in a fair and just manner, then they're going to be more accepting of the outcome, whether it's, good or bad for them. So hopefully as we do this longer, we see good outcomes for people who come through the process on a parole violation, and that if they feel like they got good treatment as they moved through from their attorney, from the officers, that they have better outcomes as they move their way through the system.
That's such a great insight. I really appreciate you raising that, because I think there's a desire to find examples of procedural justice in action, whether it's with the police department, with a courthouse. So now to have it at the parole violation hearing stage is really powerful, because it's an ability of taking the foundational premises of procedural justice and applying it in a daily criminal justice system process. So I think that's a great point. And for the visual learners, the page 4 in the Yale revocation report does have a nice flow chart depicting what Attorney Vila just walked through. I appreciate both the description of the various hearings and that point about procedural justice. I think you have some content up next, Attorney, about disposition and sanction details.
Yes, and I have to put on my glasses because I can't read it. I still can't read it. We had 377 cases that went from start to finish and have been disposed, finally disposed. We're no longer involved with. 40 of those cases involved the same clients who came back for a second or a third violation. We currently have 186 matters pending. 348 preliminary hearings have been held. 43 of those resulted in findings of no probable cause. So 43 of those 348 preliminary hearings ended at that stage. There was no probable cause finding, and so the person's parole was not violated, and they were immediately back on parole or special parole. We had 256 final revocation hearings according to our numbers. We hand counted these numbers. My secretary did this, so they may be off a little bit from what Yale or our chief public defender's office has in terms of numbers, but they shouldn't be off too much. But we had 256 final revocation hearings. 4 of these cases resulted in no findings of violations, meaning there was a failure to show a violation by a preponderance of the evidence at 4 of these, which is significant to the extent that that means the violation of parole got past the preliminary hearing stage, but at the final revocation stage, there wasn't sufficient evidence for a violation of the parole. So as a result, those 4 individuals were immediately reinstated on parole. We've also had 200 Board of Pardons and Parole's final review hearings thus far. Going on to sanction details, I would note we've had reinstatements immediately at the final revocation stage, and I referenced that above in the disposition details, 43 at the preliminary hearing stage. We also had no reinstatement for 3 of our clients, and that's generally because they've something happened on the court side where they've been sentenced to 2 years and a day, so they automatically are going to have their parole revoked and aren't going to be able to be reinstated on parole, so they count as a no reinstatement. We've had 3 clients who ended up having supplemental hearings. A supplemental hearing is a hearing that is scheduled when the Board of Pardons and Paroles does not agree with the hearing examiner's sanction recommendation, and is looking to possibly impose an increased or a lengthier sanction. When that happens, the inmate is entitled to a supplemental hearing, and we represent those clients at those supplemental hearings. And those generally only occur very rarely, and it's been my experience they only occur with situations where there may be a sex offender situation or drunk driving where somebody has been significantly hurt currently or in the past, or that the inmate has a significant history of prior violations. Going down, I'll just indicated that it's probably not of much value to the commission at this point, but we had 30 cases where people received a 3-month or less or lower sanction, and 3 to 6 month, I can't see that number here, sanction.
It's 82.
82, yeah, my thing is blocked, sorry. So we had 82 at that level, 3 to 6 month sanctions. And when we go into these hearings, we're always trying to get, as I indicated earlier, the lowest sanction possible. But generally speaking, when people are resolving their case, if they have cases or criminal violations or allegations of a violation as a result of a criminal or motor vehicle arrest, generally the hearing examiner will recommend a sanction that sort of mirrors whatever has happened on the court side. So, but not always, but generally that's what happens. So a lot of these sanction details sort of rest on what has happened on the court side if there was a criminal or motor vehicle arrest involved. The technical violations and the absconders are an entirely different category in terms of how to predict the type of sanction they might receive.
Thank you, very helpful. I think the next slide, and there's one after that, concluding a kind of challenge slide, but I think this one has some more details on sanctions and other details.
Right, and it's white because I edited this, I inserted this slide and I forgot to add the blue background. Oh. So I hope it isn't too distracting. Anyway, so we had 68 with us who received 6 months to a 1-year sanction, and then 19 who received more than a 1-year sanction. And then the other dispositions we've dealt with, we had 2 top referrals. That's where a violation has been alleged, but the parole officer has decided to request a referral to an in-house DOC substance abuse program rather than going through the Board of Pardons and Parole's violation revocation process. We've had 38 re-imprisonment warrant withdrawals, which I think is significant. And there's an asterisk there with a note that PCS has a policy now that it will request that the board withdraw the re-imprisonment warrant of an inmate with pending criminal motor vehicle charges when that inmate has been granted a diversionary program and has no other outstanding like technical violation allegations that might interfere with a re-imprisonment warrant being withdrawn. So having 38 of our clients get reinstated on parole and able to do diversionary programs such as the alcohol education program or the family violence education program, I think is very impressive. And we strive to educate our field offices and the courts that just because somebody is on a parole remand doesn't mean they can't get a diversionary program. There's some misconceptions I've found on the court side with prosecutors, public defenders, and judges that if you're on a parole remand, you're not eligible for a diversionary program, and that simply isn't true. Then we've had 7.
About that, sorry, I pressed the button, sorry.
That's okay. 7 automatic parole revocations. That occurs when a person has a criminal matter or motor vehicle matter for which they've received a sentence of 2 years and 1 day or more. Parole is automatically revoked in those situations. And then we've had 39 situations where people basically discharge off their parole sentences while they're incarcerated, so that they don't actually ever get reinstated on parole.
Very helpful, very helpful. Sorry about that. My finger, but no, it's helpful to see those numbers, and we'll have additional context and detail provided by the board, but it's helpful to walk through just those numbers. And I think these are really hot off the press numbers that you prepared for our meeting today, and especially with Professor Doherty here and just the high quality flow charts. It'd be interesting to see ways to visualize this information into some of the flow charts that were prepared for that report or through other means to help bring it to added life. But it's very helpful just to see the activity that took place beginning in September 19 with the first client through the highly unusual and challenging year of 2020 with the pandemic. So this is it's a necessary background to recognize the work that you all did through that period.
Yeah, this unit was one that really didn't miss a beat during the pandemic, that kept running, kept working. I mean, as we move into the challenges slide, I mean, that the pandemic has exacerbated that first challenge. We were working hard to educate the field offices about looking at these parole cases differently, that, there had been kind of an attitude, somebody comes in and they're on parole, that there's not a lot you could do. You just needed to figure out a way to effectively resolve the underlying criminal case. And that's not the case. Now that we have a mechanism to share information between the court side and the board, all kinds of really good creative things can be done for people, and you can end up with better outcomes. So that's been a real benefit of this, is that there is now a way for information to flow from court through our attorneys back to the board, and we just need to continue to work on that with our field offices. We were on a bit of a roll, and then the pandemic hit, and kind of everything, offices are closed. We still have some offices that are combined. I think there's 5 spots where we still have GA courthouses that are not open. So as we come out of the pandemic, to address that first challenge, it's going to be incumbent on my office to make sure that we get some good education out to the field, let them know all the good work that's being done by the parole unit, and really emphasize that they're expected to comply with the protocols, to ask everybody. That should be a standard question of everybody coming in to the building. Are you on parole? Do you have a parole violation? Do you want to talk to somebody and apply? Do you want this application for counsel to apply to our parole unit? And I think that will continue to increase the numbers and will just help us provide better services to people. So that's been a big challenge as we've gotten going. I think we'd be further along absent the pandemic, but it's a fixable problem. And then I'll let Lisa talk about the others.
The second issue we've had, and it's an ongoing, it depends on the day of the week and which facility we're talking about, but we run into some difficulties getting in touch with our clients to discuss with them their cases, their hearings, and what to expect. However, I will point out that all of our hearings are done by video conference, and the Board of Pardons and Paroles has been very flexible with us, so that if for any reason the attorney is not able to reach the client ahead of a preliminary hearing or ahead of a final revocation hearing, but it's usually the preliminary hearing that we have difficulty with, we're given time to discuss the situation and consult with our clients before the beginning of the hearing, and if necessary, we can postpone the hearing. So the board has been very helpful with regard to that.
Lisa, can I just jump in on that really quickly? We've been trying to work with corrections, and they have quite appropriately been focusing on improving their technology to do court hearings, but we've been in contact. I know the deputy chief has been in contact with Deputy Commissioner Carlo as to how we can help expand access to legal calls. With the pandemic, it's just become very, very difficult. And so we're trying to work with corrections as their technology we can provide to the counselors that will assist with video conferencing and things like that. So we're trying to work on that as well. As I said, corrections is appropriately needed to focus on getting incarcerated individuals in front of judges to process their cases. And then we're going to work on kind of ongoing improvements to legal phone calls and legal communication. Thank you.
And then we also have issues with delays in scheduling of final revocation hearings, and this is for a small number of clients, but that when clients have pending out-of-state charges, they're in like a catch-22 situation in terms of resolving their parole revocation status because they're in Connecticut and they might have charges pending in New York or Massachusetts, and how do they resolve those? And the difficulty with getting in touch with their attorneys or the authorities, law enforcement in those other states is quite challenging. And then finally, the parole officer addendum submission delays is an ongoing issue. My office, I'll go back to the beginning. When a client has a court case, motor vehicle criminal charges, they cannot have their final revocation hearing until those charges have been resolved, generally speaking, one way or the other. Once the case is resolved, then the parole officer has the obligation to submit what is called an addendum, a report to the Board of Pardons and Paroles, basically advising the board that the client no longer has any charges pending, and that triggers the scheduling of a final revocation hearing at that point. Under the regulations, a parole officer has 14 business days from the date of the disposition of a court case, a client's disposition, to submit the addendum. And 14 business days is effectively 3 weeks. And we found, heading into this, when this program started, we found that many parole officers were not submitting the addendum right away. They were, for whatever reason, whether they, and we're not sure what the real reasons were, but I think part of it was they just didn't know that clients had disposed of their cases. So anyway, my office instituted a protocol by which we advise our clients and their attorneys on the court side to notify us immediately upon the disposition of their cases, their charges. We then notify the parole officer immediately with a screenshot of the case dispositions. We notify the parole officer of the disposition and request that the parole officer submit his or her addendum. And we found that that has helped drastically reduce the delay or basically obviate any delay for submission of these addendums. However, I would point out it's quite labor intensive for my secretary to do this. So she has to get the information from the court side, get the screenshot, send an email to the parole officer and the parole officer supervisor, and then follow up afterwards if the addendum isn't submitted. It's labor intensive, but it has worked, and we've found that addendums are being submitted very quickly since we've adopted this process. But I still sort of maintain the position that the regulation should be changed. There's no need in my mind, and maybe Eric Ellison can educate me on this, but there's no need for a 14 business day lag between the disposition of a case and the submission of an addendum. We would like, and we've worked with Yale on this, trying to figure out how to address this issue, and we would ask for a 3 to 5 day submission requirement rather than 14 business days, because it's effectively 14 business days effectively keeps inmates hypothetically in jail 3 extra weeks where they might have been otherwise reinstated on parole and out of the Department of Corrections.
Very helpful insight, Attorney Viola. Thank you. You definitely created a smooth segue. I don't want to rush you, but I am curious for the board and for PCS to jump into the next section. Are there any concluding remarks that you'd like to make at this time before we broaden the discussion?
Not from me, no.
Okay, thank you.
Asking.
No, thank you for your hard work in this presentation. I'm going to quickly edit out of that and, sorry, one moment, make the transition back and putting my screen back on. Thank you. Any questions relating to Attorney Vila or Attorney Rapillo's presentation from the Public Defender Services? I think Commissioner Quiros has some thoughts, sir. The floor is yours.
Thank you, Mark, and thank you for the group. Great presentation. I'm just going to ask for patience from every state agency. The one thing that COVID-19 exposed the Department of Correction was the lack of technology. And as you can imagine, everybody now wants is calling DOC in first spot. And just remember this, these facilities were not built for me to have 10 or 15 privacy rooms. So we're very quickly getting the technology is not the problem. It's finding the space in these prisons, in these correctional jails, to provide the privacy that's needed. So just be patient, and you know, we'll try to make everybody a priority, and hopefully we can expand in the near future on utilizing the technology. Thank you.
Thank you, Commissioner. And that's one of the real appeals is your knack for IT system technology and improvements demonstrated in the kind of video conferencing technology used to provide some visitation opportunities, especially during the earlier months of the pandemic, the rollout of the tablets in the facilities, and just the ways to improve the IT wiring at Manson and some other facilities. So, you know, eager to learn more of the coming months about DOC's efforts in that area. And if there's a CJIS role here, I don't want to make any assumptions, but regarding the kind of digital workflow transfers and seamless pathways, if there are opportunities, that maybe Director Bay could weigh in now or at the future meeting on the topic. But thank you for acknowledging the IT and challenges that are is more kind of fastened into the infrastructure that make it hard.
If I could, Mark, that was definitely not meant as a criticism. The department has come, I mean, it's done miraculous things since this all started, and you know, and has set the appropriate, I mean, for what, to the extent that our opinion matters, but has set the appropriate priorities. Court, families, like they're addressing the things, I think, in the order that they should be addressing it. We're another thing on the list, and we stand ready to provide whatever we can technologically with the department, but a lot of progress has been made.
Thank you, ma'am. Appreciate you sharing that. Any questions, comments about Attorney Vila's presentation? Great. Director Sparacco, why don't I turn to you next? I'll give you the chance to, I can be getting ready to put Vilmaris and Lee's presentation on the screen. Actually, they're doing that. I'm sorry. I forgot they had the presentation ready to share. So I'll turn to you, sir, and then I'll let you hand it off to your team to take the next step, and let me know however I can help.
Sure. Oh, thanks, Mark. I think what we're just going to do is a quick overview of just numbers. You know, the numbers that we gathered from 2019 and 2020 comparatively, you know, regarding the violation proceedings. Keep in mind that our numbers include all cases that were included representation and didn't include representation. So the numbers that were presented by Chris Rapillo and Lisa include only the ones that they provided representation for. So we're just going to give you a quick overview, and we've seen some trends. I think it's important to note also, though, that we have to factor in the COVID factor in terms of some of these numbers. So we've seen some decreases that we'd like to say, you know, we can't really attribute to in 2020 because of representation by public defenders, or is it because of COVID or another factor going on? So we just thought it'd be best to, you know, just to throw some numbers out there. And this is what we've seen with the violation proceedings. I think, you know, as Director Ellison mentioned, as Chris Rapillo mentioned, there's been a lot of work, and Fiona as well, there's been a lot of work on violations. And that work started as early as 2015, and you know, and the accumulation of that work is with the of having public defenders now represent individuals at these hearings. So I think we've seen trends that are not going to be illustrative just in these numbers that started well before 2019. And you know, it was spoken about the reduction in technical violations. You know, and I think COVID only added to that. So I think you'll see some of that in the numbers. So I'm going to turn it over to Joe Garibaldi and Vilmaris Diaz to just do this presentation and go through some numbers and see if anybody has any questions. And Vil, are you ready for to share the screen?
I am ready.
Okay, I'll turn it over to you guys.
Good morning.
Good morning, Joe.
Joe, this is Mark. Thank you so much, Joe Garibaldi. It was a real pleasure to get to know you and just preparing for today, and really learned a lot about the steps that took place in the board to provide training and preparation for the launch of the unit. And we're glad that you're partnering with Bill and Lee from the research side to provide this update. The floor is yours, and take it away.
Sure. Well, as Director Ellison stated earlier, I agree with how it's made some of the field officers better field officers. It's also made the hearing examiners better hearing examiners. We've professionalized the process over the past 3 or 4 years. You know, prior to the public defenders getting involved with this process, we were preparing our hearing examiners for this day coming. We've provided really good training with judges, prosecutors, public defenders regarding probable cause, evidence. So we were preparing them for this day. And, you know, they had, offenders did have representation from ILAP, Bansley, and private attorneys in the past. So there were some attorneys involved in the process, but not to what it is now. And I really think it's up the game for everyone involved, for our preliminary and revocation summaries, our hearing examiners being more professional in their reports. I really think it's been a benefit to everyone involved, especially the offenders. They've, I think what Lisa had said before, you know, some of these offenders that come in front of the hearing examiners, they don't really know what the process is, and with their involvement in the process, it's explained to them. I mean, our hearing examiners have a long script that they read explaining the process, but when they are able to speak to their attorneys previous or prior to the beginning of the hearings, it really helps the hearing flow a little better, and they're more aware of what the process is, and it's definitely helped.
Great. So we'll start our presentation. Oh, go ahead.
Oh, no, I see. You know, here's a quick slide, and I think that Lisa pointed to this and explained a little bit about what the process is. You know, it starts with a return to custody, and then a notice is officially given within 3 business days to the parolee who's been remanded back to custody, of notifying him or her of exactly what the charges are. Evidence has to be submitted to the board, and this is all by our state regulation, which is available on our website. Has to be submitted to the board within 7 business days. A preliminary hearing, which is that probable cause hearing, has to occur within that 14 business days. And then based on the results, a warrant has to be issued by the chair or his designee within 21 business days of that return to custody in that process. Generally, following the guidelines of Morrissey, a revocation hearing occurs within 60 business days. Then and this revocation hearing is conducted by our hearing examiners. They conduct the preliminary hearings as finders of fact, and then they conduct the final revocation hearings in front of the parolee who's back on a remand without the board. They then prepare a summary and present this case to the board in an administrative review, what we call a board review, for final action. The board either adopts the recommendation. If they do not adopt the recommendation, then it evokes a supplemental hearing, of which the parolee appears in front of a 3-member panel of our board. So that's just a little bit about our process. It's worth noting. Now I'll turn it back to Bill.
Thank you. We have wanted to give you a quick summary of what our parole warrants look like from 2019 to 2020. We've separated them out by the type of violation. So we have 3 types of violations: absconder, criminal, and technicals. And we see that the 2020 warrants issued have dropped for all 3 types, and that is the warrants that get submitted and approved by the Board of Pardons and Paroles. Something to note, dramatic decrease is the process failures, and that is to the process that the attorneys referred to, and Joe has also referred to, where evidence or there hasn't been a finding made at the preliminary stage, and because of failure to provide enough documentation. And Joe, if you want to go ahead and step in and explain a little bit more about what process failures is.
Yeah, the process failures are the offender wasn't served within 3 business days. The evidence wasn't given to us within 7 business days. A remand wasn't executed properly. Those are typically fall under what process failures are. And those cases wouldn't even get to a hearing.
So we've seen a dramatic decrease in process failures, and probably due to the training and the collaboration between the agencies and departments in providing the necessary documentation. So kudos to everybody that made that happen. Here's a little bit of a summary of what the parole revocation process is, the stages that it goes through, as we explained in the earlier screen, and the possible dispositions that can happen at any of those stages. In the PDF that was handed out, it breaks it down by the individual stages and the individual technical violations or criminal violations or absconders to which each of these belong, and how many of those were for each of the violation types. Here we have some of the hearing dispositions by violation type. We have the preliminaries on the left-hand side. We see that we had an increase in the absconders preliminary hearings and a decrease for both the criminal and the technical. The technicals having the biggest drop. In the revocation stage, we see also the increase of the absconders, but also a decrease in the criminal and technicals, as it has been following the trend for the past few years. On the revocation process summary, here's just a summary of the different stages. So we have the preliminary. When we take all preliminary consideration, so absconders, criminals, and technicals, there's an overall decrease of the preliminary hearings. Total reinstatements have increased about 8%, so a slight increase on how many guys are being reinstated. And that reinstatement can happen at either the preliminary stage or the revocation stage. The cases that are being diverted through our diversion program has increased, and the total revokes, reparoles, and total revokes have decreased dramatically as well. And here is also the representation of the total process failures at the end. We also wanted to kind of give an idea of what the age groups look like by violation type. We see that on all 3 types of violations, the age group of 30 to 39 has the highest volume of them. But we also see the decreased trend on the criminal and the technicals, while in the absconder, we see a slight increase on all of the age groups. On this slide, our last slide, I think a little bit of a summary of how many days it takes in comparison to 2019 to 2020, also considering all the challenges that we've had in 2020. We see that for technical violations, the time that a offender waits for their preliminary hearing has increased slightly, but that could have been for many reasons. Again, delays in many of the processes that involved in 2020. Revocation and board actions, we see that they decreased, but again, with a grain of salt, 2020 had a lot of other inputs that affected how we process our hearings, and we also implemented new changes. The number of preliminary hearings for technical violations decreased dramatically, as you can see, and the number of warrants issued for technical violations also decreased. On the criminal side, on the criminal violations, we had a decrease in the preliminary revocation and board action hearings. Only the preliminary, the revocation and board actions had a slight increase on those. I think the biggest highlight on this table is the number of preliminary hearings for criminal violations. I think we haven't mentioned yet that the preliminary hearings happen for all technical violations automatically, but for criminals, it's only on request. So we have seen an increase in requests for criminal violations. This could be because the program is working. The word is getting out that there is representation available to them, and that we have seen an increase in. And the number of warrants issued for criminal violations is also down along with the trend of everything else. At this point, we'll take any questions.
Thank you so much for this work. And I would note that in the Yale report that was really a spark for a lot of the work that has been discussed today, there was a recommendation regarding increases in data collection and reporting. And clearly the work of the Board of Pardons, the Public Defender Division, you deserve a lot of credit for the work that you've done, the resources you've dedicated to collecting and visualizing this information, and the fact that you can produce it for this meeting at this point in the process shows that data is driving a lot of the work and reflection. Along with the presentation that Phil Marius and Joe Garibaldi just went through, I did attach to the meeting materials and post on the website actually, how long is this? A 5-page report from the board that is not as visualized in a presentation format, but walks through a lot of detailed data that was well summarized and visualized in the presentation. So for those who are hungry for more data, that might be helpful to delve into. Any questions or feedback from the commission regarding the presentation? Great, thank you. I thought I would turn next to Director Ellison and the Department of Correction for any additional reactions and input. And then with any remaining time following, we'll perhaps acknowledge the next steps. I can suspect already that with the time of the meeting ending at 11 today, there will be a lot of work that will stream out of this. We may not be able to do as rich a discussion about next steps, but I hear a lot of this meeting being an opportunity for everyone to come back together who's worked on this, reflect on the impacts to date, and then maybe chart out some next steps. So I think that from that vantage point, mission accomplished. Director Ellison, I'll turn to you, sir, for any further reactions and insights or questions.
Yes, Mark, thank you. I appreciate that opportunity very much. Thank you both for the presentations from the board, Rich and Vilmaris and Joe, and then Lisa Villa. Great to hear from you again. It's been a while since we've spoken, but thank you. Great presentation. I did want to let you know we are committed to working with you to address any concerns related to the addendum submission. We did create, through discussion with you, and last year we created an automated process for notification. If we're missing anything there, we want to see why we're missing it. So I'd be happy to take a look at any of the cases that are not meeting the statutory requirement. In that automated notification process as well, there's an escalation. So it would, if it's not submitted in a timely manner within several days, the notification then goes to the supervisor, ultimately to the deputy director, and then myself. So, but we want to take a look at any cases that are being missed by that process. I agree with that. That's important to get those hearings scheduled once there's a disposition. And Lisa, you mentioned the TOP program in your presentation, and that, just for the commission, for their benefit, for their information, if you're interested, that's a program that we put together in collaboration with our DOC Addiction Services Unit, and the funding for the curriculum and the training was through our SRR grant. It's a University of Cincinnati curriculum, evidence-based curriculum, and training was provided by UC staff, and we worked very closely with Deputy Warden Violette. So we use that program really as an intermediate intervention. That's if we don't believe that the inpatient program, or certainly the preference is always that community treatment, outpatient treatment first, if necessary, inpatient treatment in the community, but then the timeout program to, again, avoid that violation and provide treatment, substance abuse treatment, and a very sound, solid program as well. And I, in my remarks earlier, I wanted to mention all the work that the board did. Rich mentioned it. The board really overhauled and took a comprehensive look at the entire hearings process, and really greatly enhanced the due process for the population. So that's something that our officers, it took them a while to adapt to and to to get some training, but I was pleased to see some of the outcomes that Vilmaris presented today. We're getting better with no findings. We're getting better with the timeliness. We're getting better with all of the comprehensive reform measures that the board took. So that contributes, again, I believe, to the reduction in the technical violations that we're all looking for, that balance of public safety and providing support to those that are looking to reintegrate. So those are my comments. Thank you very much for the opportunity.
Thank you. Thank you, Director. I appreciate it. Professor Doherty, hope you don't mind, I might turn to you just for your reflections and thoughts. I saw you smiling at various points. I was too. I saw myself nodding. You seem to be too. So it seems that you're very pleased with what's coming out. And I know that when we were preparing for today's presentation, we were all regretting that perhaps due to the pandemic and just the impact it's had on people being stretched in different ways, we hadn't engaged with you or your students. So we're so grateful you joined, and we would love to hear any of your thoughts or questions at this point.
Thank you, Mark, and thank you for those presentations. I'll just say three things that really stood out to me. The length of the sanctions. When we first started looking at this in 2015, it was not uncommon at all for people to get a year for a technical violation. So we saw in the numbers just how dramatic that shift has been. The preliminary hearings. When we first started looking at this, there were very few preliminary hearings. In our study, 94% of people waived their right to preliminary hearing. So now just the number of preliminary hearings that are happening, which are an early chance to test the evidence, and we see how many cases that Lisa and her team have been able to challenge appropriately the evidence, and people are being reinstated. Another thing that was really exciting to see was that there's some movement on the automatic remand for parolees, in that like people who are eligible for diversionary programs are now being able to go into those programs. And I think that's one area that we really saw that there was opportunity, this idea that everyone on a parole violation was being brought to prison for at least 3 months, with even if the court was ordering bail, was really just another window of opportunity to really push through meaningful reforms. But it's been a pleasure to see how much has been done, and we're really would be delighted to re-engage in all of this. But just want to, like Vilmaris worked with us since 2015, giving us data, just being incredibly transparent. Rich, Eric Ellison came and went with my students, I can't say how many times, and it's just a pleasure to see all of you and to really applaud the changes that have been made.
Very helpful for those quick insights and thoughtful insights. Professor Doherty, I really appreciate it. And I hope it feels validating to just demonstrate ways that data analysis and qualitative assessment and legal research can lead to the changes that can produce these outcomes that we're discussing today. And one thing I was also struck by was when this work to professionalize, refine, dedicate attention to actual operations and processes uncovers additional opportunities for improvement, to apply the evidence and the science about what works to change behavior among people who are in the criminal justice system and around parole. And so there is a deep connection and between what happens in the community to the parole violation hearing process and their responses. So I think this work that was covered today will unpack further opportunities to refine policy and practice to achieve better outcomes for the system. So I don't think I'm overreaching to say that in my preparations with Attorney Rapillo, Director Sparacco and their teams, they were interested in re-engaging with the Samuel Jacobs Criminal Justice Clinic and just see about opportunities for documenting, because it can be very hard with a limited staff that's applied to this to find ways to produce the reporting and capture of the work that's being done here. So we have new data now to analyze and report, and I think some really strong next steps. Recognizing there are just a couple of minutes left, I would wonder if final concluding remarks from you, Attorney Rapillo or Director Sparacco, just to give you the floor. Sorry, we're the clock being what it is, but it would feel right to end with some insights from you all if you would wish to.
Well, just I think the process has been very collaborative, so we just organically will move towards next steps. There's ongoing. I mean, you heard from everybody that there is ongoing conversation. Is new ways that we can improve are discovered. I think that's happening, and that's what you want. You don't want to have to convene a task force every time you want to change something. You want to get good professionals together who engage in ongoing review with themselves, and I think that's what's happening here, and that's what will continue to happen. We're excited to keep doing the work.
Scalpel-like approaches yield typically the best, most sustainable and durable outcomes. Rich, how about you? Any insights from your side? Appreciate your team's presence here.
Thank you. No, and I echo Attorney Rapillo's sentiments. I mean, I think this meeting is an example of how we have worked together and where we are. And I really appreciate Fiona's comments because we have seen a marked change. And the only reason why we've seen that marked change is because we've all been able to be around the table at different points. We don't always agree on everything, but we move forward together. And I think that's the key. And we've operated so that we've seen a change in this entire process. So I thank my staff. I thank Eric's staff. I thank Chris's staff, everybody who's kind of worked toward this because we're making a better process. So I'm pleased, and I look forward to continue meetings on this. So.
Terrific. Well, my sincerest gratitude for the Board of Pardons and Paroles, the Division of Public Defender Services, the Department of Correction for their work, to the presenters we had today, from Lee to Vimaris to Joe Garibaldi to Attorney Vila and more, and also to Professor Doherty for joining us today. This was a really nice reunion and a great chance to see the information. I'm looking forward to our natural next steps that will flow from this. Our next CJPAC meeting is Thursday, April 29th at 9 a.m. It'll be virtual again. I benefited from some feedback about some IT improvements I can explore before that meeting. And April's a long month. There are apparently 5 Thursdays in that month, if I read the calendar correctly, so a bit of an unusual timing. But it'll be great to be back together again. And I acknowledge and appreciate how busy everyone's schedules are. These 2 hours together, I hope, are as rich and meaningful and informative for you as they are for me. Everyone, please stay safe. Enjoy the 70-degree temperatures today, and hopefully in the coming days, have a great time, and just stay safe and be well. Thank you.
Thank you, Mark.
Thank you.